Hello everyone, and welcome to part 2, continuation of my favorite topic, top 10 things every caregiver needs to know about elder law. My previous video, top 10 things every caregiver needs to know about elder law, talked about the first 5 most common misconceptions, easily avoidable situations, or red flags to be aware of when thinking and planning for elder law. In part 2, I talk about numbers 6 through 10. So if you haven't checked out part 1, I recommend that you do that now and then enjoy this continuation. Number 6, Medicaid exemptions. This is Delaware specific. It's important to know that even if you do end up applying for long-term care Medicaid, there are some basic exemptions that Medicaid does not take into account when looking at your assets. This is a list of the most common Medicaid exemptions in the state of Delaware. As I said before, this is Delaware specific. However, I think you'll find that a lot of these are the same state to state, but just make sure that you check your state specifics. Number 1, primary residence for a married couple. So if one spouse is applying for long-term care Medicaid and the healthy spouse is living in the primary residence, then that primary residence will be exempt from Medicaid countability. Personal effects are exempt. So that includes exactly what it sounds like. We're talking about clothing, household furniture, sentimental items, even jewelry. Personal effects are not counted. One car, regardless of value. Irrevocable prepaid funeral. This can be for both the Medicaid applicant and the spouse of the Medicaid applicant. Whatever you pay towards an irrevocable prepaid funeral will not be factored into your asset calculation for Medicaid purposes. Life insurance up to a total face value of $1,500. And finally, this is a big one in Delaware. Again, check your own state, but for married couples in Delaware, the non-applicant spouse, any of their retirement accounts are not counted against them for Medicaid eligibility purposes. Those assets are exempt. Number 7, the little known power of VA benefits. There are all different types of VA benefits, but the one that I am specifically talking about today is the VA pension or VA survivor's pension with aid and attendance. Some people colloquially just refer to this benefit as VA aid and attendance. Most people are not familiar with this special kind of benefit. One of the big features of this benefit is that you do not have to have been injured during the time of your service in order to be eligible for this benefit. The basic eligibility requirements for this benefit are that you or your deceased spouse must have served at least 90 days of active duty, one of which was during an acceptable wartime period. You must be permanently and totally disabled within the definition of the VA or be over the age of 65, and you have to meet certain income and net worth requirements. If you qualify, you can receive up to $2,300 a month if you are a single veteran, up to $2,800 a month if you are a married veteran, and up to about $1,800 a month if you are the surviving spouse of a wartime veteran. This can work really well for veterans or surviving spouses of veterans who have high out-of-pocket medical costs, because those are taken into account when the VA is looking at your income for eligibility for this benefit. The VA does have a 3-year look back for gifting before you apply for this benefit. And of course, there are lots of other ins and outs to being eligible for this benefit, but I wanted to touch on it so that you can make sure that you look into this if you meet the threshold requirements so that you can see if you might be eligible to receive this extra money. Number 8, planning ahead gives you peace of mind. The most important thing about elder law is not that you are taking steps to protect your assets, but that you are putting a plan in place so that your wishes and not someone else's are carried out. Most clients that we see are so relieved after meeting with us because they know that they have a plan in place where their wishes will be honored. It's human nature not to want to talk or think about things like this. So most clients do actually come to see me when they are in what I call crisis mode, meaning that they or a loved one is already receiving a high level of long-term care. We can still help families in these situations, but I always tell people that planning ahead before a crisis is best. The more lead time you have, the more money you're able to protect, but most importantly, the more time you have to plan, the less stressful it is, and the more likely it is that you will be able to design a plan that can be carried out to your specifications for both you and your loved ones. Number 9, what is a Miller Trust? As of the date of recording this video, 25 states have income caps for long-term care Medicaid eligibility. If you are over the income limit in these states, then you have to set up what is called a Miller Trust in order to be able to qualify based on income. A Miller Trust can be called some other things as well. Some people call it an income-only trust. Some people call it a qualified income trust or a QIT or a D4B trust. All of these are referring to the same thing, what I call a Miller Trust, and this is a way to get below the income limit for Medicaid eligibility purposes. In Delaware, in 2024, if your gross monthly income is over $2,285, you are over the Delaware income limit for Medicaid eligibility, and you will need to set up a Miller Trust in order to get below the income limit. You do that by creating a Miller Trust, setting up a Miller Trust bank account at a bank, and then depositing your income that is over the income limit into that bank account every month. As I said before, doing this will get you below the Medicaid income limit. Remember that long-term care Medicaid has both asset and income limits. So you have to be below both of those to qualify. So when we're talking about a Miller Trust, we are only talking about how you can get yourself below the income limit, not the asset limit. Many people call us, believe that if they set up a Miller Trust that they are somehow protecting assets from Medicaid accountability. This is not the case. There are other trusts that we can use to protect assets from Medicaid accountability, but a Miller Trust is not one of them. And finally, number 10, when do you need to consult with an elder law attorney? In part 1 of this video, I talked about what an elder law attorney is. A lot of people don't even know what an elder law attorney is or does. So how will they ever know when it makes sense to consult with one? This is not a full list, but these are some major trigger points where if you or a loved one is in this situation, you should consult with an elder law attorney. Number 1, your loved one, be it your spouse or someone else, is entering assisted living or nursing care, or they've already been in an assisted living or nursing care situation. This is a time to consult with an elder law attorney about options. Another time would be if you or a loved one is concerned about protecting assets from long-term care costs in the future. If a loved one has been diagnosed with a chronic illness, such as dementia, MS, Parkinson's, statistically, they are much more likely to need long-term care in the future. So it's that much more important that you consult with an elder law attorney about your loved one's situation. Another common trigger point would be if you or a loved one applies for long-term care insurance and can't get it because of the medical underwriting, or if it turns out that getting a long-term care insurance policy would be cost prohibitive. So there you have it. Those are the 10 things that every caregiver needs to know about elder law. I hope you learned something, and please look forward to my other videos on my YouTube channel where I talk about elder law and all kinds of elder law related topics.